There wasn't a reading component regarding banking in the digital age. I didn't want to go that in depth. I just wanted to give you the overall picture of negotiable instruments, but we did talk a lot about checks and presenting checks to banks, that there are some rules and regulations I wanted you to be aware of. This will be a very short video. As we know, checks, they serve as a substitute for cash, and they are the most common form of a negotiable instrument. Nowadays we have debit cards, smartphones, cash, well, the cashier's checks and the certified checks, but there's all sorts of ways we're transferring money, and we're using our bank. And like I said, regarding items like checks and drafts, we have a relationship contract, either by agreement or some form of a relationship between the debtor or the person who has the bank account. I shouldn't call them the debtor, but the drawer, and the bank. And usually the person with the account is called the customer. But you go to a bank and you open your account and you deposit money. You may have direct deposit. You're going to be writing checks against it, or you're using your debit card, or maybe using something like PayPal that's attached to it. So I want you to know what the relationship is with your bank and what the liabilities are. So I said in the beginning of negotiable instruments that you have a creditor-debtor type relationship with your bank, and you are the creditor. You are giving your money to them for them to use. That's what they do. It just doesn't sit in some random account. You have a balance, but that money's circulating. And the bank is your debtor, and you make your deposits and write your checks, and the relationship that exists is one of like the agency principal relationship. As the customer, you're writing checks, and it's the bank's job to honor it as your agent as long as there's money in the account. You also have contractual rights, and they have duties that arise as your agent, and that's going to depend on what the nature of the transaction is. So oops, I guess I just jumped the gun here. Like I said, the creditor is you, the debtor is the bank, and the bank acts as your agent. So types of rights and duties. Let's talk about honoring checks. Their job as the bank is they're going to honor your written checks. But of course, there's always the stipulation that there's sufficient funds in the account to pay that check. So if the bank wrongfully fails to honor a check, and you have the money in the account, then they are liable to you, for any damages that may result in them not honoring the check when they're supposed to. Overdrafts, when they're presented with a check that might have insufficient funds, the bank has two options. They can dishonor it, or they can pay it, but if they pay it, they charge you, and they may charge you a fee for that overdraft, but they have the option of choosing, not you. Stale checks, that's checks that are presented usually longer than 6 months. They're not required to honor it after 6 months, but if they do and they pay it out of good faith, then they'll charge your account for that. Some checks actually might say needs to be cashed within a certain time frame. It doesn't mean that the check is void. Usually means that there might not be any liabilities against it. Death or incompetency of the customer, that doesn't revoke their authority to pay any items regarding checks that you have issued beforehand, but unless they're notified, the bank is notified for some reason. Stop payment orders, only you as the customer can issue a directive to the bank to stop payment on a person's account, and you must notify them within a reasonable time. If they don't get notice and they pay for it and you wanted it to stop, well, then it's not the bank's problem. But if you do stop payment and they wrongfully pay it, then they'll be liable to you. And it probably goes without saying that you can't stop payment on a certified or cashier's check, because those are issued by the bank, and the bank's already responsible for those. Checks with forged signatures, who's liable? Bank suffers the loss unless the customer's negligence resulted in it. We've already talked about the ways that a customer would be negligent, but if you weren't negligent, the bank is the one that's going to suffer the loss for accepting a check with a forged signature, meaning you as the drawee, your signature is the one that's forged. Checks regarding forged endorsements. Those are the ones that are ultimately used for the transferring process. The one, usually it's the representative of the payee's signature and who's liable. The bank is going to be liable with regards to taking forged endorsements unless any of the exceptions that we talked about come into play. But the bank is ultimately liable and must credit the customer's account. The other thing I want to talk about, electronic funds transfers. They can be, transfers for funds can happen anyway now. Use of electronic terminals, computers, cell phones. We have ATMs. We have direct deposits. We have online payments. We have point of sale systems. Those are the PayPals. Just to give you a heads up of which laws govern things like that, we have the Electronic Fund Transfer Act, which these things govern the bank. This is what the bank's required to do. They're required to provide you with monthly notices electronically. If you do use a debit card and it's lost or it's stolen, you have to notify them within 2 days. If you don't notify them, you have to notify them within 2 days, and they can only charge you for a replacement of up to $50. But if you do not give them notice within 2 days, then they can charge you $500 if it's not reported, because they need to know if somebody's got your debit card and can use it, right? So you need to act pretty quickly, and if you act appropriately, then they're governed, they're limited with these governing laws of what they can and cannot do. They have to furnish you receipts for every transaction. The bank is liable for failing to pay electronic transfer funds if sufficient funds are available. Any unauthorized use of these electronic fund transfers is a felony under federal law. That doesn't really apply to the customer or the bank. That's if somebody does something unauthorized on your account using an electronic method, they can be charged with a felony. And banks must comply with all rules regarding the electronic fund transfer. They can be held liable and suffer damages to the customer. And the last one I want to talk about, the last laws here, is these funds, fund transfers regarding wire transfers, bank accounts to bank accounts. Under the UCC, that's governed by Article 4. This applies to commercial electronic fund transfers. This does not apply to consumer transfers. So that's basically the gist of what I wanted you to know regarding banking. That kind of incorporates what we talked about with negotiable instruments. Obviously, it's a lot more in depth than that, but that wasn't something I was going to require you to review relative to this course.